Good morning and welcome to oral argument at the 5th District Court of Appeal. Before we begin, let me introduce the panel. My name is Emerson Thompson. I'll be presiding this morning. To my right is Judge Torpy, and to my left is Judge Alan Lawson. We have civil cases today, which means the lawyers are entitled to 20 minutes per side. The appellant may divide that time. Please give me an indication of how you wish to divide the time, and I will assist you. There's a clock on the podium. It counts down from 20 to 0. And I'll also give you a visual indicator by holding up 5 fingers indicating you've got 5 minutes remaining. We're here today on cases starting with Kim SEYMOUR. Before we begin, I would ask that if you have any electronic gear that you powered off or put it on vibrate so you won't interrupt your colleagues as they argue at the podium. Then we'll start with Kim SEYMOUR. We encourage the lawyers that if you can, remain after oral argument. We'd like to visit with you for just a few moments in the lawyer's lounge so that we might pass the time with you. Starting with Kim SEYMOUR versus Sharon SEYMOUR, you may begin.
May it please the court, my name is Paul R. Linder of Griffin & Linder, PA, Orlando, Florida, representing Kim SEYMOUR. I would ask that 5 minutes be allocated for rebuttal argument. Your Honors, this is an appeal from an order approving a settlement agreement. Kim SEYMOUR is the ex-wife of Douglas SEYMOUR, who died in 2005. She filed a claim in his estate for unpaid child support, which at the time it was filed in U.S. dollars, she's a Canadian citizen, approximated $350,000. Mr. SEYMOUR was also survived by his widow, Sharon SEYMOUR.
You know, it seems to me that was there a change in the dead man statute a few years ago, and can, in a situation like this, can she now testify as to what he said in a trial?
You know, that is not an issue specifically addressed by the brief, but is my recollection.
I know. I'm just curious. I'm just curious because I'm wondering how. The issue is whether or not the settlement agreement was appropriate and whether the court abused its discretion in approving it. And I'm wondering whether your client could really ever win this case at trial, since she really wasn't involved in the transaction, and the only person that can testify as to what went on in the transaction that's being challenged was the appellant.
Well, I'm not certain she was the only person who could testify, because there was evidence presented that the deed, that personnel at the offices of Charles Hanlon, who had been her lawyer, Sharon SEYMOUR's lawyer, in a DUI proceeding, and then later with her consent apparently represented Mr. SEYMOUR in the divorce proceeding, was involved in the preparation of the deed, and that the notary and witnesses to the deed were from his office. And apparently his deposition was never taken. I think Your Honor's point's well taken. I did not handle the underlying matter. I was simply retained for the purpose of handling this appeal. But analysis should be given, perhaps, to the applicability of the dead man statute. But nonetheless, the administrator ad litem in this case, apparently without taking any depositions, but simply interviewing witnesses, represented to the court that they were of the opinion they could not win this case because it was their view that there was a presumption of undue influence which arose.
Was the administrator ad litem somebody that was completely independent?
As far as I know, the administrator ad litem wasn't somebody
that was suggested by, her side, or as far as you know, the court just picked an independent lawyer to look at this. Is that right?
Well, I believe the testimony for the administrator ad litem was that he was and Mr. Wilkins can shed light on this, but I believe there's testimony for the administrator ad litem that he happened to be outside the hearing room at a time when there was a need or discussion with the court about appointing an administrator ad litem, and Mr. Moss was outside and was selected. I have not explored the relationship, and I'm certainly not here to impugn Mr. Moss's integrity or anything like that. So-
But he made a bad judgment on agreeing to settle the case, is what you're saying, right?
Well, we're saying that the court approval, the settlement agreement was conditioned upon court approval, and that the court approval appears to have been solicited in part upon a representation to the court that there was a presumption of undue influence which could not be rebutted. And in our view, as set forth in our brief, this overlooks the case law, the Goitner case.
And that's case law that you did not bring to the attention of the trial judge. You didn't make this same argument below.
Well, I wasn't at the hearing
Well,
with the argument below.
yeah, I understand you
But
weren't.
that specific argument was not made to the trial judge, although an affirmative representation.
How is that preserved for appellate review?
Well, it is my view that it is subsumed in the overall issue of the validity of the deed, and there was an affirmative representation that the law was a certain way to this judge.
But your client never argued that it was a different way, which is what you're arguing now. So, I mean, you would agree that it's at least quite a stretch to say that that was preserved just because there was a general objection to.
If a ruling of the court is based upon an erroneous conclusion of law as opposed to, or a misrepresentation of the law, it is my view that this court has the authority to correct that.
Was the judge given an opportunity to correct that misruling? That is, did someone say, Judge, you can't do that because the law is not?
There was no motion for rehearing filed. Instead, by the time I was involved, it was time to file a motion for.
So the judge never heard it, was never argued to him, but you want us to say that it was wrong because?
The only argument, excuse me, I didn't mean to interrupt.
No, you did.
The only argument to the trial court that I'm aware of is what is contained in the transcript.
Let me ask you this question. The administrator's job was to evaluate the case and see if or not the estate would take a hit by litigation. Is that accurate?
Well, the law I've read regarding the duties of an administrator ad litem is that he has the highest duty to safeguard the assets of the estate.
Well, didn't he do that? Didn't he make an informed judgment after investigation and say, here are the facts, Judge, here's what I think, that if we litigate this, I don't know that we'll prevail and the estate will be damaged. Is that what happened?
That's what he represented to the court,
Okay,
but
now-
factually.
Now, let me ask this and then you can explain.
Okay.
What standard do we review how the judge ruled? Is it an abuse of discretion? Is that the standard before us today?
Well, I believe it's an abuse of discretion unless you conclude that it was based upon an erroneous conclusion of law, in which event it ought to be a de novo.
So your argument is the judge made a decision that was not in conformity to the law and no other judge having reviewed the same facts would have done the same. Is that your argument?
That's correct, based on the law, that's correct, because I believe that the law is clear that the presumption of undue influence based on the Goitner case and also the Tarsagian versus Watt case is clear that the confidential relationship that is involved in the husband and wife relationship does not give rise to a presumption of undue influence. In those cases, explain the logic and the reason behind that, and that is because otherwise you would have a presumption of undue influence in any case basically involving a husband and wife. And it has been held to, because it's natural that a wife might be present, for example, when a trust or a deed or will is executed.
Let me ask you about the evident, counsel, or I'm sorry, finish your thought, go ahead.
Okay, my primary point is that.
Well, no, I wanted you to finish your thought because I had a question after that.
Okay, I finished the thought on that point.
All right, well, let me ask you to concentrate on another thought then.
Okay.
How about the evidentiary hearing issue? You think that's preserved for appellate review, the failure of the trial judge to conduct an evidentiary hearing?
I believe it was requested,
Well, I mean, why didn't the lawyer just, call his first witness? Judge, I call my client as my first witness. He apparently had two witnesses there, and he just made argument. He never even put anybody under oath, right? I mean, how is it preserved? Didn't ask for a continuance, right?
well, it would appear from my examination of the transcript that at the end, the court basically said that he was ready to rule, and the attorney did indicate that he requested an evidentiary hearing at the beginning of the hearing, and there wasn't time to do it, so.
Well, is that accurate? Because the way I recall the transcript, the other side said we'd like to invoke the rule of sequestration. Your client's attorney below said, well, Judge, I don't know that that's going to be necessary. If you think you need evidence to rule, then we might need to continue this hearing because I don't think we have enough time to present our witnesses. And, you know, and then the hearing went forward and there was an extensive proffer of what witnesses would have said. And as I review the transcript, there was the only time that your client objected was after the judge in fact ruled against your client. And then there was, well, now I'd like to have some evidence. But before it was only, I mean, the way he couched it, isn't this correct, was, Judge, if you think it would benefit you to have the testimony live of witnesses, we can reset this. And the judge indicated a willingness to continue the hearing if that was necessary. But it was only after the judge decided that he didn't need that and ruled that there was actually an objection.
The judge apparently ruled based upon the proffer that both sides made,
Sure.
and that proffer demonstrated that there were substantial disputed evidentiary facts, that that there were substantial disputes regarding many
But
of
at
the
no
issues.
time before the ruling did your client or your client's counsel ever request a continuance or object and say, I object to you determining this issue based upon the proffer. In fact, your client said, we can bring witnesses if you think it would be beneficial. That's the way that your client
Well,
put it forth to the judge. Is that,
I'll have to acknowledge that to the court. I mean, that you know, it wasn't until after the judge, based on the proffer and also based upon the representation of the law, made his ruling that he had to basically go with the judgment of the administrator ad litem. It's just that the record shows there's substantial disputed factual issues regarding whether the conclusions the administrator ad litem to were based upon correct law and
I guess I'm having a hard time understanding why that fact alone isn't enough for the trial judge to satisfy himself or herself that this was an appropriate settlement. In other words, why does the trial judge need to assess credibility of witnesses when there's going to be a trial if there's no settlement? And it seems like the fact that there is a credibility issue, that it's going to cost a lot of estate assets to litigate this, and there's a good chance that the estate's going to lose in the end, would be enough for the trial judge to make that decision on a proffer without having to say, well, I think this witness may be a little more credible, because the jury's going to hear that anyway. The judge can assess those risks without assessing the credibility of the witnesses, can he?
The conclusion that there's a good chance the estate is going to lose this is in part based upon whether you believe the statement that the presumption could not be rebutted. And it also was alleged that she lacked capacity and was ill at the time and under the influence of medication, but no depositions were taken in this underlying action. And there was no consideration given to the admissibility of a lot of these issues. The reality is that the proffer provided by Mr. Wynot demonstrated there were substantial factual issues that disputed the conclusions that the administrator had come to and the facts and law that he'd relied upon to come to that decision. This is the primary asset in this estate, and it was removed, and there's certainly somewhat of an appearance of collusion when you read this transcript and see how counsel for the estate and the administrator ad litem, in essence, become advocates for Sharon Seymour for approval of the settlement agreement, and that the only funds obtained by cosmic coincidence happened to be the exact amount of attorney's fees that the administrator ad litem was seeking, and not one penny more for the benefit of the estate. We feel that that the law is clear that the presumption of undue influence was not applicable in this case for the reasons stated in our brief and based upon the Dortner case and the Tarsagian case. Based on that, it is our position that it was an abuse of discretion and it was based upon an erroneous conclusion of law.
Let me ask you
that
this. Did you give us a case where the presumption of undue influence does not apply in a husband-wife context when it's either the husband or the wife that's challenging the gift? I mean, it seems like the reason for that exception to the undue influence rule would have no application when it's the husband or the wife that's challenging the gift as opposed to some...
Well, in this instance, we are in an estate proceeding. I think it's interesting that this deed was never challenged prior to the divorce proceedings that preceded and were not finalized prior to the death of this gentleman. And The law is different regarding whether property might be treated as a marital asset for divorce purposes. The analysis.
I guess my question was, and which you haven't answered.
I'm sorry.
Did you present us with any case in this context? In other words, I understand the exception that you briefed when it's a third party that's challenging the gift, but if it's a husband or wife that's challenging the gift, why wouldn't the presumption apply in that context? And do you have a case?
Well, I would cite the case of Cook versus Cook, which is a fourth DCA case, that did not recognize any. It was an action to set aside a deed for fraud in the inducement. It did not recognize the existence of any presumption, and it said the evidence does not support any theory of incapacity on the husband's part. This was a case where the husband actually had been in a detox center, and after the wife picked him up from that, she took him to her lawyer's office where he conveyed 7 parcels of property. And she apparently had told him that the only way he could save the marriage was to sign the properties over to her. And the court upheld the conveyance, stating in consideration for continuing the marriage relationship of husband and wife, he conveyed the property. No fraud, duress, or coercion or overreaching was shown. Here in this case, in the underlying action, this administrator ad litem, it's our position, simply didn't do his job in that no depositions were taken, the issues were not sharpened to be able to determine what was admissible or whatever. It is our view that this settlement was premature, and it removed the substantial and primary asset that could have been used to pay our client's claim from the estate. Thank you.
You've got about 5 minutes left.
Okay, sir. Thank you.
Good morning, may it please the court. My name is Bob Wilkins. I practice in Maitland, Florida, and I'm here representing the estate of Douglas Seymour through its personal representative, Sharon Seymour. I did not represent Sharon Seymour in the settlement of the independent action. But to sort of follow up on a couple of questions, I think, Judge Thorpe, your question about the dead man statute is absolutely right on point. The dead man statute has been repealed. Sharon Seymour would be able to testify as to her conversations with her husband. Those would all come in, and those would all have to be rebutted had that case gone to trial. In terms of the standard of review, which Judge Thompson had asked about, it is an abuse of discretion standard. If you think about sort of how this puts itself together, we've got an independent administrator ad litem, not beholden to any party, and I think the summary that Mr. Linder gave the court is correct. Tom Moss happened to be sitting out in the waiting room in front of Judge Gridley's chambers the day I came in with a request for the appointment of an ad litem. He happened to be sitting there, literally, and the judge saw him as he came into the hearing room for ex parte that morning and summoned the bailiff to bring him in. And he asked him, would you be willing to serve? And Tom Moss said, yes, Your Honor, I will, and that's how this whole thing started. So he didn't know any of the parties, he didn't know any of the issues, he simply took it as an assignment from Judge Gridley at that point.
The argument has been made that there should have been more investigation, and that if there had been investigation, deposition, in essence a mini trial to determine the validity of the issues, I assume the credibility of the witnesses and the evidence that might be presented, and then the judge could rule whether or not they would prevail at a real trial.
Well, again, I don't think that's authorized by any statute or any case that I've seen. What we've got, and that's precisely why I think that the court shouldn't have done that sort of an evidentiary hearing. A proffer, I think, is perfectly appropriate when the court's trying to decide whether a settlement should be approved under these contexts. What would be the point? I mean, if we had an evidentiary hearing, what is Ms. Seymour going to do, Kim Seymour? What is she going to do? Is she going to bring these witnesses in? Are we going to have a trial in front of the probate judge? And then he can decide, well, based on this testimony, I don't think we should settle, and then make them try it again in the independent action. And that's precisely what Kim Seymour is asking this court to do in its brief. They think that a mini trial is appropriate. I don't think that it is. I think the only questions that might be part of the evidentiary hearing would be whether or not there was any bias on the part of the ad litem, if there was any subterfuge on the part of the ad litem. That would be an appropriate evidentiary hearing to determine whether there was some reason why the settlement shouldn't be approved for something that wasn't obvious to the court. That's not what they were asking for, however, in their brief. They were asking for a trial. And I don't think that's authorized by any case law I've seen or any statute I've seen. Let me also make the point, too, and I don't think it's one that should be missed. There really are two grounds, one of which deals with the undue influence and the presumption. The other ground that seems to be completely missed in the context is the fact that the decedent admitted under oath in his divorce pleadings and even petitioned to partition the real estate that we're talking about in his divorce pleadings. Those pleadings were signed under oath. That, regardless of the validity of the deed and how the deed came to be signed, executed, recorded, that's an issue of undue influence about the deed. But let's assume the deed's valid. Let's assume that it did actually convey the interest. The problem that the appellant has is that the decedent admitted, I may hold bare legal title to it, but it's not my asset. It's not totally my asset. And he himself asked for partition of the property in his own divorce proceeding. And I think, Judge Lawson, your point is well taken as well, in the sense that the undue influence cases that have been cited by the appellant deal with where a third party is alleging that a husband or a wife unduly influenced the other to make a gift to them. The third party is the one challenging that transaction, that transfer. This case is different. The undue influencer is allegedly the decedent. It is not that someone allegedly unduly influenced the decedent to do something he wasn't supposed to do. Those are the cases that are all cited by the appellant. That's where the presumption of undue influence would have some bearing on this in terms of not having a presumption between husband and wife. Here, that's not what we've got. It's exactly as you said, Judge Lawson. We've got a wife challenging a conveyance she made to the husband on the grounds of undue influence. And there's case law that talks about those in an inter vivos transfer situation readily. Those are cited in my brief. The only change here is the fact that the alleged undue influencer is now deceased. That doesn't change the outcome. That doesn't change what needed to be proved by the decedent to be able to overcome that presumption. So again, I think the point of that analysis is absolutely correct. Let me make a couple of other issues here. And that is sort of the interplay of how this statute is supposed to work in the probate setting. Under our probate code, under section 733-612-24, 733-612 allows a personal representative to do many, many things. It gives you a whole laundry list of things that a personal representative can do without court approval. One of those things is to settle claims. So you start with the premise that the personal representative can settle a claim, and administrator ad litem basically takes the responsibilities of a personal representative when they're appointed to represent the interests of the estate. So the administrator ad litem has those same authorities within the probate code once they're appointed to represent the estate. What 733-708 allows that fiduciary to do, whether it be the personal representative or the administrator ad litem, is simply to say to the court, Judge, I want to settle this case, but I don't want any beneficiaries coming back after me personally saying I shouldn't have settled it, that I settled it too cheaply. I want to be exonerated from liability, and therefore the procedure is in our statute that allows the administrator ad litem to come forward, which is exactly what happened here, and ask the court for basically a blessing that they can be exonerated from liability. The case, the independent action, is not going to be reversible. It never was appealed. The final judgment was entered. The findings in the final judgment basically were consistent with what was in the settlement agreement, that in fact there was undue influence, et cetera, et cetera.
I guess I have some issue with that argument in that the other side was not a party to that action. I don't know how they could have appealed it, number one, but number two, the settlement was contingent upon approval of the court. So if the approval is reversed, then how wouldn't that affect the settlement? I mean, if the settlement's contingent and on the approval is reversed?
Well, actually not. I think what would happen is the administrator ad litem would have to decide, okay, am I willing to run the risk of settling this case and take the slings and arrows that may come from the beneficiary, or in this case, the creditor, later on? They could still settle the case. And I think the personal representative, the administrator ad litem in this case, would have probably settled it anyway. Because what are they going to say to...
how's that relevant to the issue that we have to decide, though? Either...
I'm not sure that it is,
okay.
but I think the point is that they didn't participate, and there's case law that says, at least there's one case in the context of an allocation of wrongful death and a participation in a wrongful death case, where the courts have allowed a creditor to participate, to intervene in an independent action. And that case is, I don't think it was cited in the brief, but it's the Continental National Bank case, where a creditor was actually allowed, the site on that is 638 Southern 2nd 1056, where the court allowed a creditor to intervene in a case that the personal representative was pursuing in a wrongful death context. And that's exactly the same standing that this particular person would have had in this independent action. The wrongful death action is an independent action as well. And the court found in those circumstances it was appropriate to allow the creditor to intervene. They didn't intervene. That decision's final. The only thing that would happen, it seems to me, if this court were to reverse the judge's approval of that settlement agreement, is simply you don't exonerate the administrator ad litem. And when he files his final accounting, or when the estate files his final accounting and the creditor objects to it and says, you shouldn't have settled that case, then the administrator ad litem will have an opportunity to defend himself and explain why he settled it, why it was appropriate to settle it, and if he's not exercised any improper judgment or otherwise collusively settled that lawsuit, it seems to me he's going to be exonerated anyway at that point in time when the final accounting is filed.
So you're arguing that we should reverse so that he can have that opportunity
No, I'm
to
not.
challenge?
Of course not. Of course not.
Okay.
I
I'm just
think-
trying to figure out how it's relevant.
No, again, I think that the point is that what he's asked for in his prayer for relief is not what this court can grant today. That's the point of that argument. And I'm probably not going to use all my time, Your Honors.
You're not required.
I'll make it fast. Again, I think I've made the 4 points that I wanted to make. Again, the main issue is that you can second guess someone's decision to settle a case all day long, but as long as they have valid reasons for doing it, and they have justification for doing it, they understand that these are not...
The trial judge who has the responsibility to do the second guessing, right? And I
Well-
assume has some discretion in that regard, right?
Absolutely. I think that's absolutely the case. The other thing to keep in mind, too, is
And
that...
they may both be wrong. The item may be wrong.
Could be.
It may have played out in favor of, it may have been a loser. And the judge might be wrong. It might, it might have gone the other way, but, they both have discretion, right?
They both have discretion. And I think the administrator ad litem, I think, filed his action. I mean, he objected and made the wife file her independent action. I mean, he didn't just resolve it by saying, okay, let's just talk about this. He made her go through litigation. And had any of your honors been there, if you had seen, they literally had banker's boxes this big of files of the discovery that they had taken on both sides. It was a huge amount of material that they had gone through before they got to the point of that hearing. The other thing, too, this particular appellant is not going to be satisfied until every last dime of the estate was expended.
Is that
to try
in
to
the
secure-
record?
It's in the transcript. It's in the transcript where she basically says that the duty of the administrator ad litem is to vigorously defend it to the end. And that's basically where they are. They think the administrator ad litem had a duty not to settle the case under any circumstance, no matter what the evidence was, no matter what the facts were, no matter whether we're going to win or to lose. Their position at the argument was that the administrator ad litem had to litigate to the ends of the earth. And that's clearly not the case. Thank you, Your Honor.
Thank you.
Just very briefly, as far as I can tell, the administrator ad litem and his attorney did not take a single deposition in the underlying action. There
Did
was
they
no-
have access to discovery that was taken in the litigation case, in the actual civil case that was started?
The actual, there was no proffer, and based on my review, it appears that there was no, in this hearing, there was no reference made whatsoever to any depositions being taken.
Was there no discovery? Were there witness
There were
interviews?
interviews done.
Okay.
The administrator ad litem said he had done interviews of certain people, but there was no sworn.
What's wrong with that?
Deposition. Well, what's wrong with that is you don't know exactly if someone is not under oath and subject to cross-examination, exactly in what admissible form statements are going to come out. And Mr. Wynot, who was attorney for Ms. Seymour, proffered evidence that there were substantial witnesses that would contradict many of the assertions made by Sharon Seymour and her attorney, such as that she represented that the deed had been signed at the courthouse. It turned out the notary and the witnesses were from Mr. Hanlon's office, who'd been her lawyer. She represented that she was mentally and physically incapacitated and on narcotic medication. It was acknowledged that there were 6 witnesses who would testify that she'd been out after 2 weeks after she'd been hospitalized partying and consuming alcohol. There were a number of disputed factual issues, but I
That was all
recognize-
presented to the trial court, correct?
That was presented to the trial court, that's correct. But the primary argument we have is at the conclusion of the administrator ad litem that he led the trial court to, at page 22 of the transcript of the hearing, is a statement, quote, and this is from the attorney for the administrator ad litem, or I believe, "The fact remains that we cannot rebut the presumption that Douglas Frank Seymour overcame Mrs. Seymour's free will and effectively took her property from her, and that the quit claim deed should be rescinded. It is our view that is an erroneous statement of the law based upon the holding in the Gortner case and also the Tersagian case that clearly states that the presumption of undue influence is not, the confidential relationship between a husband and wife does not give rise to a presumption of undue influence." That doesn't mean that undue influence can't ultimately be determined based upon the greater weight of the evidence. What we are requesting is that the court simply reverse the approval of the settlement agreement. The settlement agreement was conditioned upon court approval. They were in such a rush to get this done that apparently, even though the time for appeal had not expired, rushed right out and actually closed the settlement agreement, and the settlement agreement makes reference to how it will be immediately closed after this hearing, even though the time for appeal had not expired. So based upon the foregoing is our request that this order be reversed.
Thank you, gentlemen.